Tonight, Ghana Bar Association in the dock. Attorney General Dr. Dominic Ayine unleashes series of blistering attacks on the GBA, accusing it of hypocrisy and partisan play in the removal of Chief Justice Gertrude Torkornoo. But the GBA president hits back, saying the process lacked fairness.
The bar saw no basis to speak out about compliance with due process. The bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice.
In the absence of specific rules of procedure, the sketchy process potentially lends itself to arbitrariness and a lack of fairness. Hence the bar's resolution on the matter. It ends up being an unfortunate precedent which lacks fairness, a situation that calls for redress, if indeed we are custodians of justice.
We speak to legal luminaries to explore the implications these remarks will have on Ghana's justice system. This is Top Story, brought to you always by Telecel, Connecting Energies, and also by Shield Pension Trust, into the future with you. Now, the Attorney General, Dr. Dominic Ayine, has unleashed a blistering criticism of the Ghana Bar Association over its stance on the removal of Chief Justice Gertrude Torkornoo. Speaking at the GBA's annual conference in Wa, Dr. Ayine accused the association of hypocrisy and double standards, sparking a heated debate among some members. Dr. Ayine's critique centers on the GBA's perceived selective outrage, pointing to their silence when Charlotte Osei and her deputies faced removal from the Electoral Commission, contrasting sharply with their vocal stance on Chief Justice Torkornoo's removal. He lambasted the bar as, quote, self-serving, unquote, and alleged its amplifying position voices rather than maintaining professional neutrality.
When in 2015, an Article 146 petition was received by the Chief Justice in relation to the former chairperson of the Commission on Human Rights and Administrative Justice, Madame Loretta Lamte, the bar failed to speak out about process. Immediately upon assuming office in 2017, an Article 146 petition was filed for the removal of the chairperson of the Electoral Commission, Mrs. Charlotte Osei, and her deputies from office. The bar saw no basis to speak out about compliance with due process. But in recent times, the bar found its voice when petitions based upon the same constitutionally defined procedures were brought in respect of the removal from office of the former Chief Justice, Mrs. Gertrude Torkornoo. Ladies and gentlemen, the honest question we have to ask ourselves is, what changed? The three petitions aforementioned touch and concern office holders of three constitutional bodies critical to the sustenance of our democracy. The independence of the three institutions has been guaranteed by the Constitution. The three occupants were all women of significant repute and members of our noble profession. The three committees established pursuant to Article 146 complied with the constitutional procedure to the letter. And yet, the bar found its voice only in relation to the third petition. Coincidentally, the voice of the bar amplified the voice of the opposition. The lawyer in politics must be a voice of reason, moderation, and constitutionalism. The bar must speak out not to please governments or opposition parties, but to defend the rule of law, the independence of the judiciary, and the rights of the ordinary citizen. The Ghana Bar Association is not merely a professional body. It is a moral compass of the legal fraternity and a key pillar in the construction of our constitutional democracy. As Lord Denning once wrote, and I quote, "Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased." The same applies to the bar. Our authority as a profession depends on public confidence that we stand above the fray of narrow partisanship. Let us therefore be the conscience of the Republic, fearless when governments overreach, impartial when opposition agitates, and always faithful to the sovereignty of the people under the Constitution. And talking of sovereignty, we should desist from the temptation of inviting foreign interference in our internal constitutional processes. As a professional body, there is absolutely nothing wrong with forming relationships with like-minded foreign associations. We must reclaim our role as guardians of democracy. The voices of lawyers must not fall silent when constitutionalism is under threat. However, and excuse my language, this self-serving ingratiation of the bar into the bureaucratic structures of the state flouts the principle of equality.
So that was the Attorney General there, Dr. Dominic Ayine, but the Bar Association will not take this lying down. President Effuagate pushed back strongly against the Attorney General's criticisms, emphasizing the association's concerns aren't about politics, but about procedural clarity. Effuagate stressed that the lack of clear rules guiding the implementation of top judicial officers is a major worry, stating, quote, this sketchy process potentially lent itself to unfairness, a precedent that must be corrected if indeed we are custodians of justice, unquote. Listen to it.
The Constitution of the Ghana Bar Association enjoins us to protect the independence of the judiciary. This is a duty the association does not take lightly, and from time immemorial, the bar has fiercely performed this duty. My learned friends, we are all aware that Article 146 of our 1992 Constitution has come under severe scrutiny in recent times. For the first time under the Fourth Republic, it's been evoked in respect of a Chief Justice. The position of the bar must be stated clearly in this regard. The bar recognizes the fact that the power of removal can be exercised under Article 146, but the bar's major concern relates to the process. In the absence of specific rules of procedure, the sketchy process potentially lends itself to arbitrariness and a lack of fairness. Hence, the bar's resolution on the matter, which was as follows. The Ghana Bar Association hereby also calls for the immediate enactment of clear and comprehensive regulations relating to matters under Article 146 of the Constitution of the Republic of Ghana to ensure transparency, accountability, and fairness in all proceedings involving Superior Court justice, particularly in the context of the impeachment or removal of such officers. This resolution was passed and publicized by 30th April 2025. However, no rules were produced. It is commonly said that justice should not only be done, but manifestly be seen to have been done. The lack of an enactment for such rules in the case of the removal of the fourth highest person in the nation should be a matter of concern for all of us. These rules should have been known to all and sundry before the commencement of the process, as it greatly affects the standard to be met. It ends up being an unfortunate precedent which lacks fairness, a situation that calls for redress if indeed we are custodians of justice. We all deserve justice, from the well-endowed in society to the less endowed, from those who wield political power to those who don't, from those who have economic power and those who don't, from those who dispense justice to those who receive justice.
Well, this is Top Story, always brought to you by Telecel Connecting Energies and also by Shield Pension Trust, into the future with you. Let me bring in Abraham Amaliba, who is former director of legal of the NDC, into this discussion. Abraham, I'm grateful to you, sir, for joining here. Now, the BAT says it asks for rules governing the removal of the CJ must be made known, but nothing like that happened. How wrong is the BAT then when it says it had issues with the procedure because it lacked fairness?
Well, that is not true because I'm aware that some judges under George Wood were removed using Article 146. At that time, the bar was there. The bar didn't say the procedure was wrong.
Were those judges the Chief Justice?
It doesn't matter. It's an Article 146 procedure. So Article 146 touches on Supreme Court judges, Chief Justice, and Superior Court judges. So at that time, we didn't hear the Bar Association. The Bar, I must say, has lost its relevance. The Bar was relevant during the revolution days when it spoke against the ills in our society. But with the advent of the 1992 Constitution and our current democratic dispensation, the Bar has lost its focus. For me, the Bar behaves as though it is an appendage in the legal wing of the MPP.
Well, but this call for rules and clarity in the rules are not only being made by the judge. We have top legal brains who also called for same. Even a former Chief Justice has also raised the same thing, that there was, the rules were not fair, and they are even calling for the enactment of clearer rules so that everyone can understand how the process must go. So how then is the Bar an appendage of the opposition because they sort of made known the views of people who think that, well, this process is not clear enough?
They are not listening to me. They are only interested in asking questions.
I'm listening to you.
I am saying that if it were about rules, Justice Derry was removed by Article 146 procedure under Georgina Wood. We have Ajed Nassam. I can mention them. If it were about rules, I'm saying that the Bar would have spoken about it then. It's not about rules. They are hiding behind rules. And in any case, which of the constitutional provisions, because the Article 146 is also a rule, which of them has been breached by the removal of the Chief Justice? I just want to know.
Just because they call for clarity, you label them as being an appendage of the MPP. And you think that's
just
fair?
Because they are calling for clarity now, at the time the MPP is not happy with the removal of the Chief Justice, when they could have called for that clarity when Article 146 was first evoked.
Okay, let's stay on with me. Let me bring in Xavier Kuje, who is a PRO of the Ghana Bar Association, to have some responses. Xavier, I mean, the concern of Amaliba is that you only found your voice when it was about the Chief Justice, and they feel that this makes you an appendage of the MPP. What's your response?
Good evening, and thank you for the opportunity. Good evening to my good friend, Lawyer Amaliba. That can never be the position. I'm in where I speak. I sat in the auditorium today. I listened to the Attorney General very carefully. He gave two examples before the immediate past Chief Justice's case. He gave the example of the former Shrike boss, Madame Loretta Lamte. That happened under NDC. The body didn't speak. Fast forward, in 2017, the former EC boss, Madame Charlotte Osei, was removed under the same article. The bar didn't speak. Where lies the favoritism? So if in the past it had been done to these two people and other people affected by the same provisions in Article 146, and a new one is happening, and the bar is saying that the way we proceeding, we should set regulations setting out how we should proceed. What is wrong? Does that make us partisan? I am surprised my good friend is now able to tell why we are saying this and not what we are saying.
His concern is, as you've said, if it happened in the past and you didn't find your voice, they are wondering why you're finding your voices now.
That is why I gave you the two scenarios. The two major parties were ruling the country then. This third one has happened, and we are saying that going forward as a society that evolves, let's put in place regulations to govern this process. Will it be applied to only one group and not the other? If that is what he thinks, then he should wait for the regulations to come in place for it to be done so. Because in the past events that the Attorney General himself referred to, in the Shrag case and the EC case, it was the same 146. That's what applied to both people and at both regimes.
Well, so your point is that even if it happened in the past and you're saying now, it doesn't make you an appendage of the MPP. Let me bring you.
Why not? Kojo, if you failed to do something yesterday, is there a bar that you can't do it tomorrow or today? If you see the need to do it, I don't think so. There's nothing constant in this world except change.
But then someone would also say there is no mistake or wrong then if the other party also says that, well, because you didn't speak when, or even though you say it happened under both conditions, but you didn't speak when it happened immediately or in the immediate past, and therefore when you say it now, then you are behaving as though you're mimicking the viewpoint of the other party. There's no wrong in that.
No, Kojo, I disagree with that. I listened to the Attorney General carefully. He said our position was coincidental to that of the opposition party. He used the word coincidental, and that connotes no intention. So let us not do politics with this. We are an evolving society. Do we want to be static? I don't think we want that.
Okay, do stay with me. Let me bring in, Nia Ikoyotu. He's a former Attorney General, so he's been at that office before. I'm grateful to you, sir, Venerable, for joining us here. Now, is the AG right to compare the two, the Chief Justice and the EC boss removal, in making his point?
Well, thanks for having me. But let me say that they are not the same. As the bar president rightly pointed out, the bar, as he said, over the years, has been defending the bench. Our point, as at the time I was there, I've been very active member of the bar all the way until I became Attorney General. I was 3 times the National Secretary of the bar. I was telling somebody today, he said he had no idea. I said, well, we are getting on in years. We have always defended the bench because we don't want the bench to descend into the public arena when they are attacked. So you see, it's always the bench that the bar rather comes to the rescue. So here is the case involving a sitting Chief Justice. Obviously, the bar station will come to say a few things. Secondly, let me say that I was in a room where all the things happened. I tried to push CI 65, which are regulations made for purposes of commissions of inquiry, that this World Forces Committee could adopt the same, because it is more fair than even the High Court rules, in the sense that you would have a lawyer representing the committee, which would then call witnesses and lead them, and then allow the two parties to cross-examine. But what we were having in that room at the Do Lodge was nothing more than a case where you have, say, a petitioner and his lawyers telling their story, and a respondent and his lawyers cross-examining, which was more of an adversarial system and not a committee for fact-finding. I pushed this. They told me they would not accept it. Yet, they were prepared to say that they would adopt the High Court Civil Procedure rules and change them as and when the chairperson felt there is a need for them to depart from it, so that there are no rules. It's a fact, and the bar has said nothing wrong. I don't know whether Amaliba can show us any rules that have been made under 146 before. or any other lawyer can tell us. It is just not in existence. It is not there. And if the bar says that we need rules, I don't think the bar has heard in any way at all. In any case, there was everything wrong with this trial. How could a sitting candidate say that when they come, they are coming to remove a Chief Justice? They cannot work with the Chief Justice. And all you need is somebody to file a petition. And once you get a petition, I've made a prima facie case, you set up a committee, and all you want is the recommendation to say the person should be. And it's removed. There's everything wrong with what happened. If they say they are okay with it, fine. But they are setting a tone where another party will come and say, well, you put in this person and we cannot also work with that person. Or you are telling us that because now you have your person, whatever it is that you like or you want in the judiciary is a matter of calling the person, telling the person that do this for us. Then where shall we have the independence of the judiciary?
But doesn't Amaliba and co have a point when they say that the same rules were used on some judges of the court who were removed and nothing happened, and therefore we cannot question that the same provisions now if it's being used on the CJ?
Well, they can say so. Like the PRO told you, the fact that it was not said before doesn't mean that it cannot be said now.
But again, I mean, if you remember the Kwekubako versus the AG case in 2017, the Supreme Court called for rules. Why did we as a nation fail to enact clearer rules so that we can avert where we find ourselves now? You are in the law fraternity, if you can help us.
Well, you know that passing law is not for the Ghana Bar Association. It's for Parliament. And if it's a subsidiary legislation, it can emanate from the executive, and then it will go and lie in Parliament for about 21 working days, after which it can come into force. So those who should do it is not necessarily the Ghana Bar Association. The executive, could have always initiated it.
Interesting. Abraham, so here you are. The point that I mean, they didn't speak about Teddy yesterday doesn't mean, and I'm sure you believe and you agree that if you didn't say anything yesterday when something was bad, it doesn't necessarily mean you can keep quiet today when the same thing is being done.
The sword must cut on both sides. The knife of butcher, you see how it is? It cuts on both sides. And because the institution we are talking about thrives on confidence, if you choose and pick, then people like us will speak the way we are speaking. I am not against one bit that there shouldn't be rules to govern Article 146. But for God's sake, I am saying that these people find their voices at a certain time. And they begin to reform. For instance, I was all out for the bar when the bar issued a statement and said that with the removal of the Chief Justice, can we all hold our guns and wait till the processes are rolled out? Only for 2 weeks. We are told the MPP lawyers in the bar, forced the bar to come up with another statement. And you think that people like us should keep quiet? I wasn't born like that.
Okay, Abraham, so let's look for solutions. What must happen so that we don't find ourselves in the situation we are now going forward?
Resolution without any question from any quarters whatsoever. That must be placed on record.
Is that savior?
Yes, that's savior. I'm saying that the allegation that MPP lawyers forced the bar to pass the resolution is never true. The resolution was passed at a gathering of Ghanaian lawyers who are all members of the Ghana Bar Association. In any case, advertisements were made for that conference. Some people decided not to attend. Whatever decision that was made was the decision of the bar. It was never a question from a group of lawyers called MPP lawyers. Never so.
All right, Sylvia, I'm grateful to you. But Nia Ikwetu, I mean, you are a former Attorney General. What must happen now so that this situation we find ourselves in never repeats itself?
Well, it's unfortunate that we are having a situation where we are now classifying lawyers into NDC and MPP lawyers. And it is quite unfortunate, because there was a time that I remember some lawyers met somewhere and said they are holding NPP Bar Association, NPP Lawyers Bar Association, conference, where they invited the president who went and spoke and even asked them why they did not bring in names so he can appoint them in his next government. It is this kind of division which is going to lead us into a lot of, unnecessary public opprobrium. Otherwise, when we were in the bar, we spoke for everybody and we were not divided into NDC or any MPP lawyers.
So what do you expect must happen?
Well, the rules must be put in place. I was a very active member of the review, the Constitution Review Committee, and we have considered all these things and thought about making changes to the way the law is now, because it is just a question of getting a willing MPP, NDC sympathizer to just file a petition. And then that's it. We are doing. As we speak today, we are complaining about the 146. They are not listening, but they are going everywhere telling us that they are going to remove the 3 top echelon members of the EC. They have been telling everybody that they will remove them. Because if it can be used to remove the Chief Justice, a whole head of an arm of government, then it is so easy that it can be used to remove heads of independent bodies. And they are sure of that. That is why they keep threatening and telling everybody that that is what they are going to do. At the end of the day, you tell us it is fair when you have told everybody this is what we intend to do. So unfortunately, but I hope so that, as I said, that the Constitutional Review Committee has been put in place, adequate provisions to deal with this kind of situation. I hope that it will pass to bring in maybe the Parliament when it comes to removal. And we should hear from Parliament. It shouldn't only be President acting in accordance with recommendations of a committee. If when the people are going to be appointed, we find time and take them through vetting in Parliament, then why is it that anybody can just remove them without Parliament having an input? So we have been considering all that. So I hope, I haven't seen the final draft, but I hope that those things are taken care of.
I'm grateful to you, sir, for joining us here. Nia Ikwetu is a former Attorney General of the Republic of Ghana. Earlier, you had Xavier Kuje, he is PRO, Ghana Bar Association, and also Abraham Amaliba is former Director of Legal for the NDC. This has been Top Story brought to you by Telecel Connecting Energy, Shield Pension Trust, Into the Future with you. Up next is Newsnight.